Okay, I make it 4:35, so I think let's get started. Good evening and welcome to this webinar. We will start actually speaking in a few minutes. Please can you ensure that you've joined an interpretation channel in English, French, or Portuguese by clicking on the interpretation icon, which looks like a globe on the bottom of your screen. And you can select the language that you'd like to hear. Matty, can you do that in French, please?
Bonsoir et bienvenue à ce webinaire. Veuillez vous assurer que vous avez rejoint un canal d'interprétation en anglais, en français ou en portugais en cliquant sur l'icône d'interprétation. Cela ressemble à un globe sur les contrôles de la réunion en bas de votre écran. Vous pouvez alors sélectionner la langue que vous souhaitez entendre. Nous allons commencer dans quelques minutes et on va vous demander de couper le son de votre microphone et vous allez sélectionner votre canal d'interprétation en cliquant sur l'icône d'interprétation. Merci.
Okay. Thank you. I'm guessing everyone has managed to find their way into the correct channel. So it just leaves us to start then. So good evening and welcome to our second webinar in the Judges in Africa webinar series this month. And we are focusing on judging in election years. I am Joelle Barnes. I'm a lecturer with the Judicial Institute for Africa, which is part of the Democratic Governance and Rights Unit at the University of Cape Town. For those of you who've just joined, we have interpretation available. To access it, please choose your language by clicking the interpretation icon. This is the second of 8 webinars that will be hosted by JIFA and the African Network over the next 9 months, each taking place on the last Thursday of the month at the same time. The first 4 webinars are focusing on topical issues affecting the African judiciary at the moment, and tonight we're looking at elections. Next month, we're looking at the topic of courage and some personal reflections on being courageous in tough times. And in October, we will consider the role of transformative constitutionalism in judicial education. Then in January, we will pick up with more specific topics addressing particular judicial training needs, and those will be advised well in advance. As I said, tonight we are discussing elections. This topic could not be more aptly timed, with 100 countries holding elections around the world this year, including 19 jurisdictions in Africa, 2/3 of which are occurring in this last half of the year. Judges play a variety of roles during election years, from sitting as electoral commissioners to hearing election petitions, and we seldom, if ever, take time to reflect on those roles or share experiences across jurisdictions. We also seldom engage with what support or even training could assist judges in these roles. And so we're delighted this evening to have 3 eminent judges join us to have a discussion here. But first, I'm going to offer the floor to Justice Tumi Woods to explain the purpose of these webinars and briefly introduce JIFA and the African Network for Judicial Trainers. So, Matty, I will hand it over to you. Matty, you are muted.
Yes.
Thank you.
Thank you, everyone. Thank you, Joelle. And good evening to everyone. You are most welcome to this, our second webinar. Just to set the background a little bit, I am the academic director of the Judicial Institute for Africa, and we are based in the Democratic Governance and Rights Unit in the University of Cape Town. And just to put it very briefly, JIFA is a regional judicial training institution. We offer all kinds of programs to create opportunities for the standardized and sustainable provision of judicial education for judicial officers. 2 years ago, we began getting, I suppose, a lot of communication from various judicial institutes across the continent of Africa. And it became more and more obvious that it would be in our advantage if we could collaborate together and use each other's expertise in terms of the training institutes' work across Africa to basically try and shape a future where there would be competent judiciaries contributing to democracy. And because of that, we held our AGM, and we've had, as I speak, there are over 20 different jurisdictions who have the network for judicial training. And it is in the space of that network that these webinars are being brought across the whole country to get us talking and discussing and debating and supporting each other. Thank you very much.
I lost internet right at the end there, Matty, and I think that you were handing it back to me. Which is why everyone's standing in silence. I apologize for that. So thank you, Matty, for doing that, for introducing it to us. Then, without any further ado, I'm going to jump into the introductions of our speakers and then hand over the mic to the three discussants to each reflect on their personal experiences and reflections on training needs for judges in election years. We will then open the floor to any panelists or participants to make observations, reflections, or ask questions. This is an opportunity to engage in cross-jurisdictional discourse, and all interventions are welcome. You may also write any questions in the chat section at any point in this evening, and we will pick up on those during the discussion period. Great. So our first speaker this evening is Judge Dhaya Pillay. She is a South African judge on the Labour Court and High Court of South Africa, and she has sat as a commissioner on the South African Electoral Commission since her appointment in 2018. Judge Pillay has a reputation of standing strong in the face of abuses of power and has not been one to shy from making unpopular but principled decisions. She has made a name for herself as a judge who pursues transformation through law and as a defender for human rights. She's also a well-loved law lecturer and has lectured at several universities. And so, Judge Pillay, I wondered whether you would do us the honor of starting off our discussion this evening.
Well, I was excuse me, hoping to be the last one to speak, because that's polite as the host, and our guest should be the first to go. But here I am, put on the spot, but that's fine. Let's do it. I'm going to try and be disciplined, because diplomacy isn't exactly my forte, and I don't want to get into trouble with anybody. So I'm going to talk about examples when I do, without mentioning names, and you can figure for yourself who I'm referring to and what I'm talking about, and just do a Google if you need to find out a bit more and identify the culprits. But my pitch today is a never-ending conundrum that judges have, whether we're dealing with electoral law or any other law. And that is, sorry, I don't have a speech, but I'm just going to share some thoughts. So the conversation I want to start is, how do judges make decisions about electoral law? And what I want to do is to present to you the traditional binary of formalist approaches and substantive approaches to interpreting law. Well, you would have gathered from the introduction that I come from two ends of electoral law. And the one is, I used to be a judge in active service, and now I'm in active service in election law, being the judge commissioner. So I have the privilege of seeing it from both ends. And now I'm a client to lawyers who present our cases to judges. And yeah, so as I was saying, that this distinction between formal and substantive approaches to interpretation. It is a binary, and I don't like binary, so I'm going to put this on a spectrum and see what we're going to discover in between. So for this discussion, I want to also give three broad areas of adjudication, without saying that they necessarily are segmented in this way, but rather for the sake of convenience of making a distinction between the kinds of cases that must be adjudicated in election work. So the first that falls, I would like to say, within the formal category, as would be the kind of cases that relate to whether an organization has complied with the strict requirements of the Electoral Acts, the regulations, the timeframes, and so on. So it would include whether an organization is properly registered, has complied with the time limits for advertising, has paid the fee, and is properly nominating its candidates, that its candidates are eligible. Those sorts of formal requirements for which you need to read the black letter of the text of the Constitution or the legislation to know what is to be done. The second category around which judgments and adjudication takes place is to examine whether the structural arrangements are in place. We're having this conversation, obviously, in the context of assessing whether we are a functional democracy where all the requirements for a democratic state exist. So are the structural arrangements in place? These would include, is there an independent court? Of course, is there an independent election management body? Is the media independent? And is there a robust opposition? So these four ingredients, there are several others, but these are the critical ones that we look at when we go into any election observation exercise. The third category that I want to highlight is, are there substantive compliance? Is there substantive compliance with the requirements for democracy? Not just the law, but of course it includes the law, but are the tenets of this democracy functioning? And so this would be an interrogation into whether, notwithstanding the structural arrangements, you do indeed have an independent EMB and a court that is not subservient to a dominant party or any particular individual, but which is able to act independently, impartially, and is accessible to litigants, the population, and so forth. So I'm hoping to move from what I think should be formal decisions of reading the black letter of the law towards looking at more nuanced decisions about interrogating context. Having made these distinctions and talking about context, I am not in any way suggesting that when we apply black letter law, we are ignoring context. Context matters at every level. It's a degree to which it matters in particular circumstances. What I'm saying is the easy cases that we would like to call easy cases are those where we can look at the law and say, these boxes are ticked, and therefore that decision must naturally follow. And that I would like to think in election management law would be the kind of cases that deal with registration of the organizations of political parties, of candidate compliance, and all the other good things that go towards making readiness for elections. And the deeper delving into substance and opinion and discretion would come into an interrogation as to whether there's substantive compliance. And there we're looking, as I said, at whether the different components of the four components of critical components of democracy are working well, that democracy and the right to choose representatives, accountability are working well. Let's go back to the formal requirements. Now, when I say context matters, the context in which the laws exist arises from years of practice, experience, and pragmatics. So, for instance, there's also the requirement of consultation during the legislative process, and within the election management bodies, there's consultation within the political parties. There's a platform for a political party liaison committee at national and provincial levels. And the legislation is generally passed through them, and they have a say in how things should proceed in an election. So it's a very dialogical process through which legislation emerges, and for courts to disregard that is problematic. It it creates uncertainty, it creates instability, it causes election management bodies to run around at short notice to comply with court orders that change this regime. And of course, when you do things in haste and under those conditions, when strict time limits have to be complied with, the scope for mistakes becomes greater. And so when we used to talk about deference in the old days, when we, well, the days of apartheid, and even earlier when we talk about constitutional adjudication, when we come across a bad law, we used to say, oh, judicial deference applied and black letter law applied, bad judges, bad decisions. But with electoral law, I would venture to suggest that there must be more caution, because this law, these regulations are the product of extensive dialogue, extensive practical experience of what works and what doesn't work. And let me use the example of our own jurisdiction here. So there was a reason there were the political parties, parliament, not just parliament actually, it's a constitutional assembly that opted, which is a big difference, opted for representative parliamentary democracy, multi-partyism, and that representation in parliament will be through political parties. Things went awry along the line, and representatives became unaccountable, dissatisfaction amongst the voters, and then this caused some scrutiny of the law to see whether this framing of our electoral system was good enough. And so it came about that a matter landed before the Constitutional Court by a party which has not participated in the elections on the eve of the 2019 elections. The matter was postponed then, and between that and the local government elections, the Constitutional Court had to make decisions, and we had to get the Electoral Commission to get its act together to comply with that law. The gist of that law was to introduce, in addition to political party representation in Parliament, independent candidates have the right to stand for elections, and people have the right to vote for them. Then the net effect of that judgment is that, notwithstanding the amendment of the law to cater for this, there wasn't a single independent candidate who was elected to the National Parliament. A huge amount of expense was incurred in this process, in the amendments, the education, the rollout, 3 ballots. By the way, it takes 25 trees to make 1 ton of paper. That's just an aside. And we needed about 880 some odd tons of paper for this election. Also, so it became a very expensive education process, a very expensive election. I'm not saying that the courts shouldn't look at the laws, and I understand 100% why they intervened in the way that they did to open the door to candidates. And of course, there's a reform that would come, is expected down the line. But let's go back to the easier cases that came. We were faced with some 28 cases, election-related cases, many of them related to non-compliance with the strict requirements of the legislation. The legislation, the strictness of it, is really a great asset for all of us, particularly the administration, because we have no discretion, or very little discretion and choices. Either you meet the deadlines, either you give us 1,000 signatures, either you have no previous convictions that are still alive and 5 years have not abated. Those are the things that we tick the boxes for. We don't have a discussion. Whether we like the party or not is quite irrelevant. And so those cases were set down. Now, I understand that there might be good reasons for setting the matter down, and I would imagine that it might have been hard on the courts to do as previous courts have done, to say, there's no merit in this case, we are not setting it down, go away, and let us go on with the case and with the management of the elections. But there's another school of thought about what might be appropriate dispute resolution, because a party who is aggrieved might feel more appeased if there was a proper hearing and the courts heard both parties and ventilated the dispute and gave a written judgment. So those are the tensions that I expect that the courts would be experiencing. But there's also the practicalities. And I'm hoping that the precedent set in these many cases, none of which were lost by the IEC, strict formality applied. And please tell me when I'm getting out of hand as far as time is concerned. Okay, so we won all the cases. I've got to say that. And I hope that going forward, these would be precedents that anyone wanting to challenge the strict requirements of the legislation and the regulations would have will think twice, because in as much as the court and the IEC have been reluctant to ask for cost orders, we are doing that now because, firstly, the reason why we chose not to ask for cost orders in the past is we want to make the courts accessible. We want people to follow process, and we don't want people to take to the streets and to have an avenue, a legitimate avenue to ventilate their disputes. So, but now, once we've got these judgments, it would be frivolous, vexatious litigation if people disregard the precedent and try their luck when formal application of the law provides an adequate solution to the judgments. And also remember, if you're challenging the law, there's a big gap between the elections and the promulgation of the law. Don't come on the eve of an election and then try your luck. Okay, so much for the formal compliance. And I would like to suggest that when judges look at the electoral law, to think favorably about applying black letter law, strict compliance, call it formalism if you wish, but technical compliance is quite important when it comes to electoral law. The structural arrangements, that's not hard to figure out. In our democracy, we have, and in many democracies that I've had the privilege of observing, most of these instruments are there. The trouble is who populates them. And then that moves me into the substantive compliance question. If an EMB is appointed by the president, doesn't necessarily matter and doesn't necessarily compromise independence. All the members of the IEC are appointed by the president, but there is a parliamentary process before that. And Parliament and the members there have an opportunity. There's also an interview process, which the public have a right to comment on. And so there's a cleaning up of the commissioners and the applicants for the commissioner post before the president appoints. But if the chairman of a commission, an election management body, has been an advisor to a president of the country and the incumbent, and is appointed by that president, then people wonder. You're cautious, but when the election results are such that there is non-compliance with the anticipated prescribed procedures, then you start interrogating the substance of that democracy. Yes, the EMB has certified the elections as free and fair. And indeed, the court has upheld that decision. But here's the dilemma. The system of that jurisdiction is such that you have electronic voting supported by physical ballots cast. So every time the machine receives your click, it generates a piece of paper that says you voted for Mr. Candidate X or whatever, and that gets put into box. And if the EMB is relying only on the electronic vote and has not allowed access and has not counted the paper, then you question the integrity of the elections, the integrity of the EMB, the media that supports the EMB, the courts that support the EMB. And at the same time, you wonder, where was the opposition? If in an election, the opposition is annihilated by court cases, disqualifying them in various ways from participating, and there are few jurisdictions where this has happened. Now, it may be that charging an opponent for fraud or whatever, money laundering in one instance, might be quite correct, quite appropriate, legitimate charges, good conviction and prosecution. Because even opposition parties and politicians, some politicians, are not averse to corruption, money laundering, and so on. So if you're an opposition party member and you are charged and you go to jail before an election and you are therefore disqualified, may be perfectly legitimate. But you also wonder, why now? As an adjudicator, as an election observer, you wonder, why now? And it's one of many factors that make up the context in which elections are held, and contestation is, when it is adjudicated, must be taken into account. So if the opposition has been annihilated, well, something's going wrong. Let me pause there.
Judge Pillay, can I? Yes, I was just going to say to just come to a conclusion, because there are some questions already coming in for you. Well, are we going to take the questions at the end after the three?
I think let's do that, because then we can reflect on them together. Thank you, Judge Pillay, for giving us such a broad overview of the different contextual aspects and the different aspects of compliance that need to be addressed. And I think such a good starting point for our discussion going forward. And so I think that creates a bit of a context within to have the next discussion, which is to swap across to Justice Elisa Samuel Boerekamp, who is a High Court judge in Mozambique, and hear another perspective from a different jurisdiction. Judge Boerekamp is the High Court judge and a general director for the Center for Judicial and Legal Training of Mozambique. And she has also got a very rich and diverse background, particularly as she's very well known as a human rights activist and someone who's bravely stood up against executive interference with the judiciary. She's also a renowned trainer and passionate about the rule of law. So it is wonderful to have you here. And perhaps also to bring in this element of how we prepare judges to work within this very difficult context, but also all of your reflections. So Justice Boerekamp, if you'd like to take over.
Thank you, Joel. Thank you, Judge Pillay, because she helped me a lot posting all these questions. And congratulations for your work and your bravery. We need judges like you to inspire us as young judges. And from my Mozambican part, I see a lot of colleagues of me that they will help. I mean, they will have this conflicts, electoral conflict in their courts. So thank you very much. But as we do have a translation, I will switch to Portuguese so that they can understand me better. And I hope, Stefan, I will speak slowly so that you can translate also properly. Thank you. So now, okay. So switching for Portuguese, trocando para o português. Eu queria começar.
Yes, we can.
Yeah, can I
Yes,
start?
please.
Ok. Então, eu queria começar por cumprimentar calorosamente a todos, portanto, primeiro aos organizadores deste evento, a Rede Africana de Formação Judicial, da qual o Centro de Formação Jurídica e Judiciária de Moçambique também é membro, e a JIFA, Judicial Institute for Africa, através da Matilda, que é a diretora executiva, e da nossa querida Vânia Hart, que também está a acompanhar-nos. E também queria cumprimentar, obviamente, aos participantes e estimados colegas, juízes e juízas de Moçambique, da África do Sul e do Malawi. Para mim é uma honra estar entre profissionais tão dedicados e comprometidos com o fortalecimento do sistema de justiça, por um lado, especialmente num momento tão crucial como são os anos eleitorais. Bem, o objetivo da minha apresentação, eu queria fazer aqui uma ligação com o que a nossa querida juíza Pillay esteve a falar relativamente aos requisitos formais, portanto, que devemos prestar atenção quando estamos a julgar em anos eleitorais. Ela falava, por exemplo, da questão da lei e da necessidade de haver consultas prévias, portanto, no momento da elaboração da lei eleitoral ou da revisão da lei eleitoral, há consultas necessárias que devem ser tidas. Então, estas consultas mostram como é o contexto em que estas leis são aprovadas, quais são as problemáticas, e aqui eu acrescento, quais são as problemáticas que envolvem todo esse contexto. No caso de Moçambique, esta posição da juíza Pillay vem mesmo a calhar, tendo em conta o contexto em que nós estamos neste momento a viver. Mas eu vou, primeiro, se me permitem, queria partilhar com os colegas do Malawi e da África do Sul quais são os passos que Moçambique tem estado a levar a cabo em prol, portanto, de uma atuação justa e transparente para que o processo eleitoral no nosso país seja realmente transparente. Assim sendo, eu vou fazer uma pequena contextualização que vai nos levar à altura das nossas primeiras eleições multipartidárias, que tiveram lugar em 1994, resultado da assinatura do Acordo Geral de Paz entre a Frelimo, portanto, o partido no poder, e a força da oposição, que levou o país para uma luta civil, uma guerra civil de 16 anos. Portanto, essas foram as primeiras eleições partidárias no nosso país. Dizer que nestas eleições a supervisão dessas eleições não estava entregue aos tribunais judiciais, mas sim a um tribunal internacional que na altura foi portanto, foi criado no quadro da ação de reconciliação, paz, portanto, a chamada ONU-MOS, que é Nações Unidas, Força Especial das Nações Unidas em Moçambique. Portanto, devemos assumir que nessa altura não havia tutela jurisdicional das eleições. Portanto, tudo era um negócio, permitam-me o termo, entre a Comissão Nacional de Eleições e, portanto, nesta altura o Tribunal Supremo agia como um tribunal eleitoral de última instância em tempo de eleições. Por outras palavras, não tínhamos uma litigação eleitoral, na medida em que tanto o Conselho Constitucional, portanto, que nem existia, como também os tribunais distritais não tinham esta competência. Esta competência foi dada aos tribunais distritais e, portanto, também depois criamos o Conselho Constitucional, que depois mais à frente explicarei para os nossos colegas do Malawi e da África do Sul, que é a última instância, portanto, em matérias de contencioso eleitoral. Portanto, estas duas instâncias, portanto, a primeira e a última instância, elas foram introduzidas com a lei eleitoral de 2019. Mas a pergunta sempre existiu, portanto, a pergunta sempre inquietou ao povo moçambicano, aos partidos políticos, ao grupo de cidadãos. Por que é que não se podia recorrer aos tribunais em caso de insatisfação, em caso de violação dos procedimentos, como dizia a juíza Pillay, dos procedimentos na componente administrativa do processo eleitoral, mas também no caso de haver clara violação do direito ao sufrágio. Até porque a Constituição que saiu depois de 90, ela já estabelece um quadro muito forte sobre a competência dos tribunais. E, desde então, os tribunais tinham aquilo que se chama de competência residual. Ou seja, tudo que não estivesse entregue a qualquer outra jurisdição especial ou especializada caía no âmbito das competências dos tribunais, portanto, comuns. Então, essa pergunta sempre existiu. Mas este é o passado. Obviamente que desde 94 nós já tivemos vários pleitos eleitorais e aqui entro na atualidade. Ora, na atualidade, dizer que Moçambique vive um período crucial, desculpem, na nossa história democrática. Portanto, por que eu digo isso? Porque estamos em vésperas de realizar as sétimas eleições gerais e legislativas e também as segundas eleições dos governadores para governador e para membros das assembleias provinciais. Portanto, elas representam, eu diria, um marco significativo no fortalecimento das instituições democráticas e na promoção de uma descentralização, portanto, com a realização das eleições para governadores provinciais e para os membros das assembleias provinciais, nós avançamos para uma segunda etapa, diria eu, da descentralização no nosso país. Porque antes os governadores eram indicados pelo partido no poder, portanto não havia eleição para o governador, havia eleição para as assembleias, portanto para os municípios. E desde o último pleito em que passamos a indicar, portanto, os governadores passaram a ser votados. É verdade que é num sistema de lista, mas ainda assim eu diria que foi devolvida a democracia ao povo moçambicano. Agora, no que respeita ao sistema de justiça eleitoral, a opção adotada no nosso ordenamento jurídico estabelece um sistema híbrido, como me referi há pouco, em que o conhecimento do recurso contencioso eleitoral está cometido aos tribunais comuns, de nível distrital. Portanto, os tribunais de nível distritais são os tribunais, digamos assim, na pirâmide dos tribunais, são os tribunais que estão na base, não é? Portanto, estes tribunais atuam em tempo de eleições como verdadeiros tribunais eleitorais, em primeira instância. Depois temos o Conselho desculpem, o Conselho Constitucional, que vai decidir os aludidos conflitos, digamos assim, os recursos, em última instância. A lei moçambicana, com isso, no fundo, garante expressamente o duplo grau de jurisdição em matéria eleitoral. O que significa que qualquer questão, irregularidade ou mesmo nulidade dos atos eleitorais suscitados a nível dos tribunais de distrito vão ser decididos, em última instância, pelo Conselho Constitucional. Por isso, podemos assumir desta interpretação que, em sede de recurso, todas essas decisões podem ser mantidas, podem ser alteradas ou podem ser revogadas. Ou seja, os direitos e interesses dos cidadãos, aparentemente, ainda vou lá, dos cidadãos, dos agentes eleitores, dos mandatários ou delegados de partidos políticos e demais agentes estão plenamente protegidos, não é? Ou salvaguardados pela lei e também, aparentemente, a transparência do processo eleitoral. Existe aqui uma transparência do processo eleitoral. Entretanto, porque não há bela sem senão, uma das questões candentes e, por isso, incontornável, obviamente, é o princípio da fundamentação das decisões judiciais. E aqui é muito importante o que foi dito pela nossa querida juíza Pillay, porque a motivação das decisões judiciais é o cimento que deve solidificar a confiança do cidadão sobre o sistema da administração da justiça. Eu não acredito que a lei deva ser aplicada cegamente. Não existe isso. O Poder Legislativo tem o seu poder, passo a repetição, para produzir leis. O Poder Judicial tem o poder para julgar os conflitos. E esse julgamento é feito pelas leis que são produzidas pelo Poder Legislativo. Ao fazer este trabalho, este processo, os juízes devem, sim, interpretar as leis, portanto, fazer a motivação das suas decisões. E isso não tem que ver com o que um ou outro partido pensa sobre a questão. Esta é a minha primeira a interpretação do que eu penso que deve ser o papel dos juízes. Mas todos nós sabemos que o papel dos juízes em anos eleitorais não se difere do papel dos juízes em situações normais. Ora, em anos eleitorais, obviamente, há um acento tônico que devemos colocar. Devemos colocar o acento tônico na responsabilidade dos juízes de assegurar que todas as etapas do processo eleitoral, desde o registro das candidaturas até o apuramento dos resultados, seja conduzida em conformidade com a legislação vigente. Isso envolve, obviamente, a fiscalização dos atos administrativos eleitorais, como, por exemplo, a verificação da regularidade das listas dos candidatos, a conformidade das campanhas eleitorais com as regras estabelecidas, a observância das normas que regem, portanto, a propaganda eleitoral. E aqui concorre quer o papel dos tribunais judiciais comuns, agindo como tribunais eleitorais, também como o papel do Conselho Constitucional no que a regularidade das candidaturas diz respeito. Também há que ter em conta que os juízes atuam como árbitros imparciais nestes casos e devem decidir com base na lei e nas provas apresentadas. Ou seja, as suas decisões devem ter um poder de influenciar significativamente o resultado final das eleições, garantindo que há transparência, não é? Bem, eu não sei quanto tempo tenho, mas eu ainda tenho algumas coisas aqui para dizer e vou sublinhar também uma questão importantíssima, que está muito ligada à questão da transparência, portanto, dos pleitos eleitorais, que é a imparcialidade e a independência dos juízes. Esta não deve ser arranhada, nem por um ato do Poder Legislativo, através de uma lei que impeça, limite esta independência na interpretação e aplicação da lei. E eu depois, vocês vão perceber porque é que eu estou a pôr o acento tónico nesta questão, principalmente tratando-se da situação moçambicana. Ora, e aqui entro eu na questão que nos traz à reflexão no caso de Moçambique. No caso de Moçambique, nós temos que há desafios que nós tentamos ultrapassá-los no que concerne à aplicação da lei eleitoral pelos tribunais e pelos juízes. Esses desafios têm que ver com o contexto em que nós vivemos. Acho que não é um caso, portanto, não é um caso único de Moçambique. Temos estado, como disse muito bem a Joel na sua apresentação deste webinário, o mundo está no ano eleitoral. Há eleições em mais de 100 países. Vimos o que é que está a acontecer em Venezuela, vimos o que é que está a acontecer em Índia. Filha, podes ligar aqui, estou a ficar sem carga. Vimos o que é que está a acontecer, por exemplo, em Bangladesh, por conta da ação do legislativo. Ora, esse desafio é a complexidade das leis eleitorais. Em Moçambique não foge a regra. E também a necessidade de decisões rápidas e fundamentadas. E o terceiro desafio é a pressão política. Ora, a complexidade das leis eleitorais, acompanhadas inclusive de um contexto de alterações e revisões constantes, que não nos dão tempo, ou não dão tempo, ao próprio legislativo para que faça as devidas consultas, os devidos entendimentos. Peço desculpas, eu estou a ficar sem carga e tenho que carregar o meu computador. A minha filha me está a ajudar. Ok, thank you. Portanto, eu dizia, estes desafios têm a ver com a complexidade das leis eleitorais. No caso de Moçambique, a lei eleitoral, de pleito a pleito, como dizia a juíza Pillay, portanto, o contexto, a prática, os procedimentos que nós vimos adotando de pleito em pleito eleitoral é que levam, na minha opinião, a estas alterações constantes. Mas essas alterações não dão tempo aos tribunais e aos juízes e aos procuradores para consumirem suficiente toda uma legislação dispersa. Eu vou vos mostrar aqui um exemplo do que está a acontecer em Moçambique. Este é o pacote eleitoral no nosso país, não é? Decentralization and Election Legislation Package. Portanto, isto tudo é um conjunto complexo de procedimentos, de leis e tudo mais, que nós, como formadores, como escolas de formação, devemos acompanhar também para a formação dos nossos magistrados. O que aconteceu é que, no ano passado, nós tivemos as eleições autárquicas. E por isso, as eleições que davam lugar à eleição, obviamente, das assembleias municipais e dos seus presidentes. Então, estas eleições foram caracterizadas por uma atuação dos tribunais por conta da alteração da lei em 2018, que, portanto, vem dar aos tribunais judiciais de distrito de primeira instância competência jurisdicional para a tutela do direito eleitoral. Agindo dentro deste quadro de competência, os juízes de algumas mesas da Assembleia, portanto, de alguns distritos, portanto, que cobre as assembleias de voto, agindo no âmbito de recurso do contencioso eleitoral, tomaram decisões no sentido de, portanto, alterar, não era alterar, mas anular, declarar irregularidades que aconteceram em algumas mesas, mandar recontar votos em algumas mesas. Então surge este debate de se dizer que não, os juízes dos tribunais de distrito não podem fazer isso. Portanto, não podiam anular as decisões, que esta era uma decisão que deve ser tomada em segunda instância pelo Conselho Constitucional. É uma jurisprudência, portanto, problemática no nosso contexto jurídico, que é defendida em parte pelo próprio Conselho Constitucional, mas também há uma componente muito forte da doutrina, da opinião pública, política, jurídica, que entende que não. Os tribunais de primeira instância têm todo um poder para tomarem decisões de acordo com o princípio até do pedido, não é? Portanto, nós estamos a entrar para as eleições que vão acontecer agora em outubro com essas expectativas. Portanto, os juízes estão a entrar com essa expectativa. Então, devemos ou não devemos, portanto, alterar, mandar anular, mandar recontar os votos, em caso disso ser pedido em tribunal de primeira instância. Ok? Ora, foi com base neste contexto que os três partidos com assento parlamentar, a Frelimo, a Renamo e MDN, portanto, fizeram a revisão da lei eleitoral, a revisão da lei que dava poderes, portanto, aos juízes, aliás, a lei sobre a qual os juízes tomaram as decisões que me referi no ano passado nas eleições autárquicas. E esta questão da revisão da lei foi feita, digamos, faltando 2 ou 3 meses para nós, como escola de formação, iniciarmos. Sim? Can I continue? Posso continuar?
There we go. Sorry, someone else is on the line. But Judge, yes, if you don't mind just bringing it to a close, and then we can pick up on some of the matters
finish.
that you're bringing, because it's really good
I will
stuff.
summarize. This is very important, Jolly. I'm sorry. I will summarize.
Yes, please.
Thank you. Ok. Como eu estava a dizer, portanto, perante a formulação, reformulação ou revisão da lei eleitoral, a Assembleia da República, portanto, como dizia, com assento parlamentar, com os partidos que têm assento parlamentar, 2 votaram a favor da alteração que tem sido interpretada como sendo a retirada do poder ou das competências dos juízes dos tribunais de distrito, que são os juízes de primeira instância, de mandar recontar os votos ou a declarar nulas as eleições naquela jurisdição, na sua mesa, portanto, no seu distrito, que é a área de jurisdição de onde cada tribunal se encontra. Eu preciso referir aqui que em Moçambique vigora o sistema de representação proporcional na vertente de onde, que é também conhecido como sistema de distribuição de assentos em órgãos legislativos, como assembleias municipais, provinciais ou nacionais, com base na proporção de votos recebidos por cada partido ou lista de candidatos. Portanto, como podem imaginar, este método, no fundo, tende a favorecer partidos ou listas com maior número de votos, embora ainda, enfim, proporcione uma representação para os partidos menores, mas em comparação com os outros sistemas de representação proporcional, este método pode ser um pouco mais favorável para partidos maiores. Então, em contextos eleitorais como estes, que o uso do sistema de representação proporcional pode implicar uma composição dos órgãos eleitos, portanto, que diversifique opiniões e preferências dos eleitores. Então, é um método cujas decisões judiciais, quando são tomadas no sentido de afetar a contagem de votos, validar ou invalidar uma candidatura, bem como decidir sobre a distribuição final de assentos parlamentares, pode ser, portanto, pode nos levar a uma governação muito mais transparente. Então, foi este poder que foi retirado, na minha opinião, portanto, dos tribunais de distrito. Então, esta questão tem que nos levar a refletir sobre o que disse a juíza, e com isso termino, sobre se o nosso papel como juízes é meramente de aplicar a lei cegamente e não olharmos para estas questões, não é? Lembrem-se que foi com base nas decisões tomadas no tempo da Primeira e Segunda Guerra Mundial, sobretudo com o sistema nazista, nazista, que levou a que juízes, pela primeira vez na história mundial, sentassem no banco dos réus para serem julgados por fazerem o seu trabalho. Os julgamentos de Nuremberg são uma lição que nós não devemos esquecer quando se trata de interpretar a lei em favor da dignidade da pessoa humana, em favor dos direitos fundamentais, e aí sem ser o direito ao sufrágio. Então, o meu apelo, a minha posição é que temos que interpretar a lei não tendo em conta o contexto em que os partidos políticos juntaram-se para defender uma posição que lhes e diga-se de passagem, partidos políticos maioritários, com assento no parlamento, têm interesses próprios, tá? Em detrimento da maioria, que é o povo que vai às urnas para escolher os seus representantes. Então, é preciso que a gente traga estas questões na formação dos juízes, no âmbito da interpretação da lei eleitoral, no âmbito da interpretação do direito do sufrágio, e por isso, no fundo, estaremos aqui a emprestar a nossa a visão, a nossa missão a uma democracia, a um Estado que se quer realmente democrático. Porque se nós vamos olhar para o princípio da separação de poderes de uma forma restrita e dizer que não, nós não temos, os juízes não têm que fazer leis, sim, não têm que fazer leis, mas o juiz deve interpretar a lei. E ainda para mais quando, substancialmente, esta lei põe em causa princípios fundamentais, como sejam os direitos fundamentais. E com isso termino, é verdade que não falei sobre o que estamos a falar sobre a formação, mas eu, entretanto, irei
so that we can move on and come back for a general discussion after the next speaker. Thank you.
I'm sorry, Matilda, I was in the Portuguese translation, so I didn't hear you. But thank you very much, and I'm sorry, I get a little bit emotional with my presentation. But yes, you're right. I will come back with the training.
Brilliant. Thank you so much, and thank you for highlighting the importance of those aspects, particularly the tension between the integrity of the law and the integrity of judges, and protecting those aspects, and the role of the courts in interpreting these complicated areas of law and within the context of the country. I think it's a good for us now to shift to our last panelist. So thank you so much, because that we can go across to Justice Kachale, who is a Malawian judge who had the very overwhelming task of leading the Malawi Electoral Commission in the 2020 elections, just after the 2019 annulment. And I'm sure he'll pick up on some of the matters that have been discussed by our two other panelists. Going into this role as Commissioner, Justice Kachale was also the chairperson of the Judicial Training Committee for Malawi for 5 years, and he's an established academic amongst his other notable achievements. So, Justice Kachale, I wonder what your take are, what your reflections. I'm sure we're all interested in the post-2019 being the commissioner at that time, but also your other thoughts on the Electoral Commission and your process in Malawi.
Thank you, Jolie. I'll try to be brief. So thank you for the introduction and the opportunity to share a few thoughts. First of all, I'll just say briefly that So I've had the opportunity to reflect on these issues from a purely academic perspective in my PhD work. And then I think everything came together. In 2019, May, I voted. And in December 2019, I was working as a consultant on legal reform and electoral legal reform in Sierra Leone. In 2020, I was back in Sierra Leone to do some training for the Electoral Commission. And then come June 2020, I found myself as an election management body chairperson. So basically in my academic work, I had put forward the suggestion that the legal culture of the judiciary is more important than the legal reform that you get by amending the text of the law. And I personally believe that the jurisprudence that came out of the courts in 2020 validates that postulation, because in Malawi, in 1999, reading the exact same provision of the law, the courts had interpreted the word majority to mean a simple majority. And fast forward 21 years down the road, an entirely differently constituted bench, which was actually comprised of a more constitutionally oriented bench than the previous bench, which had actually been comprised of judges who had served under the autocratic rule of Dr. Banda and had a more literalist and textual perspective on interpretation, as opposed to the more substantive and constitutionally informed bench of 2020. Reading the same law, they came to a different judicial outcome, which actually produced a very transformative constitutional jurisprudence that, in my view, was promoting democratic legitimization of the whole electoral process. So the demand for a more credible election was reflected in the manner in which the courts shifted from a purely quantitative analysis of electoral process to actually reflect on the qualitative aspects of the whole process. And the significance of their decision to me can be evidenced because if you remember 2019, 2020, that was the era of the COVID-19. And the public health crisis of COVID-19 presented its own challenges to the government that had been elected in the contested elections. And every measure they tried to propose to manage that process was being resisted, as you can imagine, because people were interpreting it to be an attempt to avoid having the rerun or the fresh election. But when we had a fresh election, the exact same measures that had been proposed by the exact technical team that was in place were fully embraced by everybody else, just underscoring the value of ensuring that you have credible and acceptable electoral outcomes, which actually promote democratic legitimacy. So, in my experience, I think one of the things I would like to, some of the thoughts I would like to share in this regard is that there is a need to underscore the training of the judges and the bench if you are going to get strong judicial outcomes that actually consolidate or contribute towards democratic consolidation. And if I was to summarize one of the key thoughts I would like to share, I would say that technical proficiency and political sensitivity are very critical in the manner the bench handles its role insofar as election-related legal disputes are concerned. So it's not enough for you to just know the text of the law or to know your jurisprudence. You also have to bear in mind the political context within which you are discharging your functions. So if I was to go towards something, I think we haven't had enough reflection on this far, on what's the nature of the training needs. I would categorize them in two, basically. You need legal training, but you also need ethical training. Now, in terms of legal training, obviously, you need to be very well acquainted with the jurisprudence, get access to the latest decisions, but also get access to the latest legislation. Because as a matter of good practice anyway, after every polling event, the election management body is supposed to undertake some legal reforms that are informed by the reports of elections observation teams, but also the experience of their implementing that event. So when you are approaching a new election, don't assume that you know the law. Get acquainted with the law and be familiar with all the legal instruments. So that's a very technical level of training. But also, I think conceptually, you need to get acquainted fully with the electoral cycle concept that informs how elections are run. And I think a good appreciation of the electoral cycle concept can actually alert you to some cases you may be handling without fully recognizing their implication on elections. So you may be dealing with issues of procurements of some sensitive materials, and yet those procurements are being procured to support the electoral process. Or some cases may come in the context of recruitment and employment. Maybe there may be questions about the legitimacy of and the transparency of recruitment in some key positions of that election management body. But if you're not thinking in the context of electoral cycle, you may miss the significance of those disputes insofar as the ultimate credibility of the electoral process is concerned. So on the legal elements, I would say there's the jurisprudential training, there's the conceptual framework within which you handle the election matters. So you need to get fully acquainted with the electoral cycle concept, that elections are not an event, elections are a process. If you are going to have voter registration, for example, that is being constructed upon the civil register, you may well find out that issues that arise in the context of registration of citizens have a serious implication on the integrity of the voters' roll. But if you cannot think in an integrated fashion, you could easily miss the significance of one issue in the context of electoral process. So you need to know the jurisprudence, electoral cycle. The third point I would say is the mechanics of elections. That's what I've called it. You need to get acquainted with the mechanics of elections. What do I mean by this? I would talk about three issues: there are technological issues, there are logistical issues, there are political issues. Okay? So unless you understand how electoral technology functions, you may not appreciate how your judicial decisions have implications on the practicality of actually managing the process. So for example, if the court, without appreciating what technology is available on the market, for example, proposes that only people bearing certain documents are people who are eligible to register, and yet there is no technology on the ground to support that form of registration technologically, you could end up creating a mess and a headache that may not be easy to overcome in the context of implementing the elections. But also, if you're not familiar with how the technology functions, you could easily come up with decisions that don't add value to the work of the Electoral Commission. So in my view, there is a lot of need to have what I may call familiarization sessions between the bench and the technology that the EMB are going to use in running an election, so that they can better appreciate how the law actually impacts upon the work of managing an election, and how all that can affect the integrity or otherwise of that process. In terms of logistical issues, like I said, there may be questions of procurement and so on. You could very well pronounce a judgment that requires certain new technology to be procured, but depending on your jurisdiction, there are different public procurement regimes that require certain processes to be complied with if everything is going to be legit. And if you're not fully aware of those implications of the legal decisions that you're making on the logistical capacity of the EMB to procure those kind of equipments, you could come up with jurisprudence or court decisions that actually impede instead of promoting a fair and transparent and credible electoral process. The political context, I think these are issues to do with media coverage. You could be dealing with a case of access to information. You could be dealing with cases of whether the public broadcaster is giving equitable coverage to all the different players. And you must be aware of how this can impact the political landscape to ensure that you have a fair political process. You could be talking about issues of campaign and political party financing. All those issues could promote the fairness of the process, and you must be aware that they all add towards creating a very credible political outcome. You could be talking about questions of political party registration. If certain criteria or thresholds for registration are set in a manner that's not inclusive, you could actually be curtailing the political space and therefore inhibiting the level and quality of political contest and undermining the whole political process. But you could also have disputes about primaries in political parties. How are they being run? Are they being run in a fair and inclusive fashion? In our context, I think I can give the example of the challenges that female political contestants have raised about the challenges they encounter, the barriers they encounter that actually limit their active participation. And now, if you're sitting in a court and you're encountering cases of that sort and you're not aware of all the gender nuances that are actually at play in that context, you may miss an opportunity to actually create a more fair playing ground for everybody to exercise their political rights. So you need to know the mechanics of elections, as I call them, in the technological, the logistical, as well as the political context. Secondly, on the ethical questions, I think having worked in the, I think there's Yusuf Warda who has asked a question about some of the challenges you encounter sitting as a judge during the context of political, elections. When I got into the space as chairperson of Electoral Commission, I was the sixth person to occupy that office, but four of the previous occupants of that office never finished their term. Two of them died in office. The other two were recalled because of public clamor against them. And the third, the one I had just replaced, when she left office, she had to leave the jurisdiction and lived abroad for quite a few years. So I was very well aware of the level of risk that the office brings with it, but I had received no adequate briefing or training as to the practical implications of that, not only on my own life, but on the family, on the life of my family and even close friends. I really do believe that if we're going to be fair to judges who have to assume responsibility for managing elections, we need to provide adequate training or appraisal of the risk that is involved in assuming this responsibility, because it has a bearing on your capacity to discharge the function. And you also need to appreciate some of the security implications of handling sensitive political cases. I know the colleagues who handled the 2019-2020 dispute, especially at the Constitutional Court level, the immense challenges. We're just having I think 3 months ago, we had a meeting with the Supreme Court and High Court judges, because some of them have since moved on to the Supreme Court, hearing the harrowing experiences of abuse, physical threats. Even we know that we have had a case where somebody was prosecuted for trying to bribe them. There are so many risks that attend to your handling this very high voltage political disputes, if I may call them that. And sometimes you are assumed to know what you ought to do. And I don't think that's realistic. I think there is a place for ensuring that judges receive appropriate information that can help them make the right decisions, but also take the appropriate measures to ensure that they are not at risk, their families are not at risk, and even their professional name is not at risk. You should have a mechanism for even a robust response against some of the vilification. Some of the stories that went on social media the moment my name came through as a judge sharing that were so horrific and abusive. But I guess as a judge, my own experiences, your integrity will vouch for you in the end. If you are prepared to do the right thing, even the naysayers can turn around and recognize that maybe they spoke prematurely, but it can be very tough and intense. And in my experience, having a very strong social support network, but also a network of professionals who are understanding and empathetic goes a long way to actually ensure that you can do that work and do it competently and without it destroying your life, whether professionally, emotionally, and otherwise. Let me stop there.
Thank you so much, Judge. That was a wonderful overview. And thank you for picking up particularly on those legal and ethical training needs and requirements, particularly the personal implications of the role and the need for familiarization with the process. I think those are two very key points to come out of your submissions. And so we will open the floor to some discussions now. Matty, would you like to start us off with that?
Before I go to the floor, I see that Judge Bidassa from Togo is with us. And I would just like to hear from him the Francophone experience, because they have just had elections as well all over Western Francophone Africa. And I just for comparison's sake would like to hear from Judge Bidassa, just for comparison purposes. Judge Bidassa? May I gather that he's not hearing us and he may have been knocked off. Okay. I think we have almost a holistic appreciation of the practicalities, the difficulties that arise during election years, both in terms of the judge's role. I think it is the first instance where the judiciary is no longer the poor cousin in the separation of powers. Okay, all eyes are on the judiciary. And that pressurized atmosphere, apart from putting a lot of tension in the country, also puts huge expectation on the judiciary to deliver. And I think this is what all the three speakers spoke about and gave us some tips about how to go about that. And I think all three judges told us that we have, first of all, to know the law. You have to know the law inside out. You have to understand the law. You cannot apply the law if you do not know the law. And for those of you who are judge trainers, I think the importance and the stress should be on that. The emphasis should be on training judges on the who take election cases to be really well versed with the law. And I suppose also the highlight was on the need for really ethical officers and the need to be courageous and to do just what the law needs of us in those circumstances. I had to deal with one aspect. I suppose I had to deal with the presidential elections in my own country, in Seychelles. And in my case, and I think I speak for a lot of other jurisdictions, it is especially even harder when it is the electoral process is you are talking to a very bipolarized electorate. Doesn't matter what you do, the pressure is going to come from both sides. And it is, with empathy and actually with sympathy that I think of you all who have to deal with such cases, especially if you have no security. People have been killed, people have been injured, and we need to take that on board as well. It's fine for us to speak to judges and say, you have to be brave, you have to be courageous, you have to do the right thing. I think being in their shoes gives you a different perspective altogether. So I think today, the tools and the tips given by the three speakers is especially helpful, and I thank them for that. So perhaps, Joel, if you could take some questions from the floor while I go to the chat, because quite a few questions have come from the chat. So while I do that, perhaps you can take the first questions from the floor.
Fantastic. We are close to the end, but I'm not going to cut off the discussion right yet. I feel like we're getting to the juicy part. And so if anyone has anything that they'd like to ask or discuss or reflect, please feel free. And that also goes for our panelists if you'd like to respond to anything that's been said or pick up on anything from your colleagues.
Okay, Judge Dlamini from Eswatini put a question directly to Justice Pillay about her take on independent candidates in the electoral process. Is there a distinction, Justice Pillay, Judge Pillay, in terms of independent candidates and party candidates?
Yes. Well, we had a system until the 2019 elections of just party candidates being participating in the elections. But after the Constitutional Court declared the law unconstitutional, there was an amendment and introduced, as I said, independent candidates. So I think the question was, do I have a view about independent candidates? The thing is that it is the question is what works. And but let's start with the Constitutional Court judgment. It is the legislation and the Constitution itself is open to the interpretation that the court gave to it. So you know, that my concern was not about the interpretation of the law, which was entirely within the realm of interpretations. What our concern was that it came from the court at a time in the midst of an election cycle when both the candidates, the political parties, and the electorate had very little time to engage with the changes. And it would have been far better if it came through a parliamentary process, through the ordinary course of writing up a law. But that is why we kind of did a stopgap measure, and we've got we cobbled together some kind of system where independents can participate. But there is a panel, an electoral reform panel, that's going to look at that and see whether the bar is set too high, too low, and what kind of models can be revised. That would have been a far preferable arrangement and a way to go about amending such an important area of democracy. And I mean, the candidates themselves stood to lose a lot because if you didn't win a threshold of seats, you lost your deposits. So and they were quite significant. So it's sad that independent candidates didn't make it. It would have been interesting to see how they played out in Parliament and what kind of alliances would have emerged. But that was my concern. I don't have any bias for or against the formulation.
Thank you. Can I ask Judge Boerekamp or Judge Chifundo? We have a question from Yusuf Voda, who's a senior research associate at the University of KwaZulu-Natal. He speaks a little bit about what I just spoke about in terms of the inflamed situation around elections, and if there's anything that can be done to protect judges from being drawn into the cut and thrust of politics.
And politics being what it is, you can't run away from having to adjudicate over the disputes that arise from that have got a legal nature. But like, for me, in my experience, there needs to be practical logistical arrangements to actually provide physical security, enhanced physical security where you have a physical risk to the security of a judge. You need to have a robust media team that can actually take on some of the lies that are actually being peddled against the judges that actually undermine their credibility. So you need to think in a very holistic fashion to ensure that, because we are living in a very information sensitive culture, you cannot avoid a scenario where the judge is going to be entirely insulated from that barrage of attacks. But if you neglect to respond to some of those attacks, the insidious impact of some of those insinuations about the credibility of a judge will actually affect how well the decision they render is received. And in my view, there is a place for being much more responsive and robust in pushing back against, because sometimes the losing candidate will deliberately undermine the credibility of the judicial officer because the outcome is well known, and they're trying to ensure that the outcome is not well received by a certain section of society. So, in my view, there's need for a little more innovative thinking around how you handle some of the negative media campaign that goes to reflect poorly on the judges. And ultimately, the strongest bulwark against any suggestions of unethical conduct is the integrity of a judicial officer. So you want to ensure that you have a bench that has got the moral capital to weather that political storm, because that storm will come once in a while. But if you have got a bench that's got the moral capital to actually come out of that unscathed, then you have a chance for your judiciary to become actually that bastion of pushing back against some of the high and very volatile campaigning in the media and otherwise that may go to undermine the process. But that cannot happen by default. That's why everything else, when you're building a judiciary, you must be intentional about certain things, because in these moments of crisis, that's when you can see actually whether the judicial edifice you built is adequate to provide the shelter your democracy requires in those moments of crisis.
Thank you. Thank you so much for that. Judge Boerekamp, there's a question that's come in which is quite interesting, and I've often wondered myself, the timing of the international observers' report sometimes in stating that the elections were generally free and fair, whilst there's a petition just launched in the court to declare the elections not being free and fair. How do you deal with that tension? Is there anything you can do to mitigate that tension and help the courts do their job? Elisa? Steve, can Elisa hear us?
I'm so sorry. I'm here, yeah. I'm sorry, I was lost with the Portuguese translation. What was the question? Sorry.
We can't hear the English translation.
We can, Matty, if you join the English room.
I am.
Oh,
What was the question, Matty?
Can I help? The question was, how do you reconcile the tension between the court's adjudication of an election and observers' reports of it, and the timing of observers' reports? I think that was a question.
Yeah. Essa é uma boa questão, e é por isso que eu penso que nosso sistema tem que ser repensado, porque, entretanto, para o nível de tribunais de que eu faço parte, quer dizer, já não faço parte porque agora estou no tribunal embora esteja na escola, mas o meu nível não é do Tribunal do Distrito que tem a competência para julgar em primeira instância, mas obviamente que esta é uma questão que põe em causa a transparência do próprio processo eleitoral, a independência dos tribunais, a mina com a confiança do cidadão no sistema de administração da justiça e no sistema de administração eleitoral. O exemplo que eu dei do que aconteceu nas eleições autárquicas no ano passado foi exatamente esta confiança que ficou manchada. Mas a componente positiva disso tudo é que pela primeira vez o cidadão moçambicano veio à mídia, à comunicação social, a comunidade jurídica veio dar razão e veio apoiar a decisão dos tribunais de primeira instância quando decidiram em rever, portanto, em sede de recurso em primeira instância, mandaram recontar os votos e, de facto, ficou provado que houve fraude da comissão de eleições. E, por isso, mandaram recontar os votos e, naqueles casos em que a fraude era brutal, anularam as eleições, mandaram repetir as eleições naquela mesa de votação. O que veio a posterior dizer o Conselho Constitucional, como última instância para apreciar o recurso contencioso, foi que, embora houvesse irregularidades ditas em primeira instância, no fundo é o que sempre veio dizer, vistas em primeira instância, essas irregularidades não tinham a capacidade, portanto, não eram suficientes para pôr em causa, aí está o sistema de votação proporcional, para pôr em causa o resultado final das eleições. Mas a interpretação doutrinária, a interpretação da lei que se tem é que é preciso que estas irregularidades, que estas nulidades influem-se negativamente no processo, portanto, no processo de votação. Então, fica aqui, obviamente, esta questão. Ora, o que é óbvio é que os tribunais, na minha opinião, fundamentando claramente as suas decisões, descrevendo todo um processo lógico de análise jurídica, política, se quiserem, deve ser suficiente para, inclusive, os observadores internacionais perceberem que há aqui problemas neste processo eleitoral e declararem dessa forma. Claro que são questões de soberania nacional, obviamente que como é que se diz? Os observadores internacionais, a comunidade internacional, não há de vir, portanto, dizer de forma aberta que sim, a decisão do tribunal é aquela, nós concordamos com a decisão do tribunal, nesse ou naquele sentido, pelo menos não em Moçambique, a gente não vê isso acontecer, mas a verdade é que a função dos tribunais é exatamente essa, de declarar que há aqui irregularidades, que este processo não foi transparente. Mas, como disse, feliz ou infelizmente, esta atribuição cabe ao Conselho Constitucional. Vocês podem me estar a perguntar, mas o Conselho Constitucional não é composto por juízes? Sim, é composto por juízes, mas os juízes do Conselho Constitucional têm uma indicação política. Portanto, quem indica os juízes do Conselho Constitucional são os membros, portanto, do Parlamento, que tem assento maioritário no Parlamento, é que indicam, portanto, esses juízes do Conselho Constitucional. Então, aí é muito complicado, embora também tenham, segundo a Constituição, uma vez indicados, são independentes, mas pronto, nós estamos numa democracia ainda infante, que vai requerer um processo até lá chegarmos. Mas a verdade é que já chegamos a este processo. Os tribunais de primeira instância, esses sim, que têm uma eleição, digamos, não é eleição, mas o processo de nomeação destes juízes é um processo democrático, aberto, não tem indicação política. Essa primeira instância consegue tomar decisões imparciais e independentes. Ora, questionam-se as decisões do Conselho Constitucional na medida que a indicação dos juízes desses tribunais, tirando um que é indicado, portanto, pelo Conselho Superior da Magistratura Judicial, porque é a composição do tribunal, o resto é questionável, porque são indicações políticas, e por isso, bem, é complicado estarmos aqui a falar de uma transparência total nas suas decisões. Obrigada.
Thank you, Elisa. There's just one last text there which I will address to Judge Chifundo, because Judge Chifundo, you talked about the challenge of technology sometimes, and the question that's coming across is if thresholds are set by the law for registration, and the thresholds themselves are a challenge because of technology, is it appropriate for the judge to step into that gap?
Obviously, it depends on the jurisdiction, but in our context, if there's a legislative instrument that is curtailing the constitutional right to participate in a political process, that instrument can be challenged for being unconstitutional because it's being restrictive. So just because you've used technology or legislation to create thresholds that are actually creating a barrier for people to participate in the process, that's not the end of the process. If somebody takes that law or technology to court and say, this is inhibiting participation because of ABC, then that's a constitutional analysis that the court must undertake in order to verify whether there is a violation or not. And where the court finds that the instrument is restrictive in an unconstitutional fashion, the courts will be entitled to interfere and actually take that back, require the legislator or the EMB to create instruments that do not inhibit enjoyment of political rights. So yes, I think the courts have a part to play, because the courts must ensure that there is strict adherence to the constitutional guarantees of political participation and all the other rights that are implicated in the electoral process.
Thank you so much for that. Back to you, Joelle, now, if there are any last questions or any last comments.
Just wondering if anyone else has anything they'd like to ask this panel of speakers.
Joe?
Yes, please.
If I may just comment, I share the views of my panelists that you know, in our last elections, we had to have security, extra security, and it's a dangerous occupation, this being an election management service. And yeah, but the points that that judges are making decisions as a matter of urgency in a highly charged political environment. Now, those two factors doesn't necessarily mean that judges are political. And that's the charge that is made of judges, that you are playing politics. So when you have to decide a case about technology, are you being a technician then? But seriously, what is a judgment? And that's the guide for me always. A judgment is the production of evidence, arguments before an independent person called the judge, who makes a decision based on that information and the application of law. So even in a politically charged case, there has to be an application of law for the decision to be a judgment. Otherwise, it is not a judgment if there's no law applied to the facts. That's all I wanted to say. Thank you.
And perhaps to engage with that concept further, Judge Pillay, what do you do when there is a gap in the law? In that case, because in so many instances, and I think in this technology space, where and I know that you've talked about the strict formality, but Justice Kachale also spoke about the courts being cautious not to curtail the political space. And I wonder what happens in our typical hard cases.
Well, you asked me my favorite question. And let me start by saying that, judges make decisions that are not agnostic to their life experiences. As Judge Kachale pointed out, that a panel of judges some 20 years ago came to a conclusion which was reversed much later. So both context and the caliber and the life experiences of the judges feed into that. So what happens when there are gaps in the law? So Duncan Kennedy answers this question excellently, because he informs and freedom and constraint. In freedom and constraint, he talks about this shifting between to and fro between facts and law, and it is a choice between particular facts and a choice between particular rules that determines a judgment. And what influences those choices of fact and the application of law? And it's all a matter of the legal representatives who present the case, the judges who get to choose which facts they like and what law they're going to apply. But it has to be law applied to the facts to close the gaps. Thank you.
If I may, Joel.
Please.
From experience in 2020, the courts mandated Parliament and the President to put in place new legislation to actually reflect the changes they are pronounced in the law. So the requirement for a 50% plus one threshold to be attained, what would happen in a runoff. The law was passed through Parliament, but the sitting President refused to assent. And they were using that argument to say, then you can't run an election. So we were caught up in a space where if we adhere to what the executive were proposing, we would ourselves be in breach of the constitutional law court order to say within 150 days run a fresh election. And our approach was, in the event that we encounter a situation that is not properly canvassed in the existing law, the courts would offer guidance, because we were in a serious constitutional crisis. So in our view, we took the legal position that there can never be a vacancy in the law. There can never be that kind of a gap. Nobody can hold the whole system to ransom by refusing to put their pain to a process and then create a constitutional crisis. We took the responsibility to say, insofar as we have a mandate to run this process, if we encounter any problem, the courts will come and fill us in, and we will actually take it to the courts, and they'll come and pronounce on that, because the Constitution does not have any space for it. There's never a vacuum. For me, the judicial officer is not a clerk. He is a custodian of the whole constitutional instrument and the whole constitutional system. You cannot be clerical about that huge onerous responsibility. You're gonna have to be creative. And in my view, my experience is that as long as you can demonstrate that you're pursuing legitimate constitutional interests that are for the public good, then the public will support you and you get through that process. So actually, the law only came in after the new government came in, and so many changes were made, and so many gaps were being realized to say, how did you do this like this? Well, we realized that this gap was being created. So for example, I'll finish on this. They were supposed to have 3 commissioners elected from one party and another 3 elected from a separate party. The ruling party deliberately put in 4 and only took 2 from the other. And they were trying to create a litigation issue. So initially, the other party rushed to court, but I think somebody prevailed on them and said, you're playing into their game. They want you to go to court so that the process doesn't happen. So they allowed the improperly constituted commission to run the fresh election. The new government came in. Then they went to court, challenged the appointments. The other 4 commissioners were all dropped off. A new cohort came in, and then they were like, How could a illegitimately constituted commission run a legitimate election? As well, that's the whole principle of constitutionality. Insofar as that's a body that was in place, they had to do the work. But you knew what you were doing. You deliberately constituted an improperly. So to me, I believe there's enough space for what I call constitutional creativity to ensure that you maintain the constitutional order where some gaps are being created to actually undermine the very system you're trying to protect and build.
Brilliant. Thank you for that. Thank you for that discussion back and forth. And perhaps this comes back to where we started at the beginning, when Judge Pillay was talking about the dialogical development of the law. And at the time, she was mentioning of electoral law within the legislative space, but also the dialogue that happens between the legislators and the courts with each cycle of elections, and the importance of having that dialogue and continuing the development of electoral law as it goes forward. With that, unfortunately, I have to draw our discussion this evening to an end. We have run over, but I'm so grateful for the engagement this evening, for the discussion. I know that we weren't able to take every single one of the comments in the comment box, but I hope that everyone has enjoyed the discussion that we've managed to have this evening. And on behalf of JIFA and the Judicial Network, the African Judicial Network of Judicial Trainers, we're really grateful to our speakers for joining us this evening. And thank you for your time, and thank you for your insights, and for the difficult and important jobs that you do. We really appreciate it. And just a reminder that we have another webinar in a month's time. So join us to talk about the difficult experiences that people have and when they need to use courage as judges. Thank you, everyone.
Thank you, Joe.
Thank
you.
Bye-bye, colleagues.
Thank you. Bye.
Thank you.
Bye.
you so much.
Bye-bye.